Welcome to the last part of protection of human rights. We were seeing the European Convention on Human Rights. Here, the European Courts on Human Rights. Judges are nominated by contracting state. There are two categories of applicant under the European Convention on Human Rights: the contracting state and when you see the procedure, the condition of admissibility, there must be a prima facie violation of one or more of the provisions of the European Convention on Human Rights. The available domestic remedies must be exhausted. The application must be lodged within 6 months of the final decisions of the highest domestic court or authority. An application will be rejected if it is anonymous, if it is similar to case already been submitted to another procedure of international investigation or settlement, if it constitutes an abuse of right, that is a complaint, for example, it is brought for political propaganda purpose, if it concerns matters falling outside the scope of the European Courts of Human Rights. The procedure on the merits: the chamber decides cases by majority vote. The judges are allowed to give separate, dissenting or concurrent judgments within 3 months of the judgment of the chamber. Any party may ask for referral to a grand chamber. It is possible if the case raises a serious question affecting the interpretation or application of the convention or the protocols or a serious issue of general importance. The final judgment is binding on the respondent state concerned and its execution is supervised by the Committee of Ministers. In the European Union, the protection of human rights have acquired two dimensions. First, many issues relating to human rights arise under the European Union internal or external competences. The second dimension is that human rights are envisaged in a broad content in respect of all European Union policies as being part of general principles of GEC laws, that is European Courts law. Article 2 of the Treaty on European Union. The Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect of human rights, including the rights of persons belonging to minorities. These values are common to the member states in society in which pluralism, non-discrimination, tolerance, justice, solidarity and equality between women and men prevail. When you see Article 6, the Union recognizes the right, freedom and the principles set out in the Charter of Fundamental Rights of the European Union on the 7th December 2000, as adopted at Strasbourg on 12th December 2007, have the same legal values as that of the treaties. The provisions of the Charter shall not extend in any way the competencies of the Union as defined in the treaty. The right, the freedom and the principle in the Charter shall be interpreted in accordance with the general provisions in Title 7 of the Charter, governing its interpretation and application, and due regard to explanation referred to in the Charter, that set out the sources of those provisions. The Union shall accede to the European Convention for Protection of Human Rights and Fundamental Freedom. Such assertion shall not affect the Union's competence as defined in the treaty. The fundamental rights as guaranteed by the European Convention for the Protection of Human Rights and Fundamental Freedom as the result from constitutional tradition common to the member states shall constitute general principles of Union's law, that is the European Union's law. The European Charter of Fundamental Rights. First, the document adopted by the International Governmental Conference in Nice, December 2000, as the Declaration Non-Binding Proclamation after the Treaty of Lisbon in December 2009. It should be treated as a primary law of the European Union. The Charter contains 50 articles. The main purpose to make fundamental rights and freedoms more visible, more explicit and more familiar to the European Union citizen. Conclusion marks. Efforts made by the international community to ensure the protection of human rights, which have just been established or proclaimed, are certainly encouraging, but they must be assessed in the light of what many nations are actually doing. The respect for human rights cannot be confined to mere declaration, which is soft laws. So far as the United Nations is concerned, its effectiveness in the enforcement of human rights is still weak for many reasons, and the most important being it is not mandatory. Therefore, there are many states unwilling to submit themselves to any external scrutiny. There is no judicial mechanism within the United Nations to deal with individual complaints. The reporting and the monitoring system is still based on confidentiality. The Security Council has not taken any consistent or firm stand in respect of states violating basic human rights. The principle of non-interference in domestic matters and political assessment of human rights situations often prevail. When you see at the regional level, apart from Europe, where the protection of human rights is well advanced, there is a very large credibility gap between promises which are easy to make and performances which either seems to be very hard to effect or in respect of which there is not the will to carry through. Thank you.